Good morning and welcome to the webinar. This is Roger Royse, the founder of the Royse Law Firm, a business, corporate, and tax law firm with offices in Northern and Southern California. Entrepreneurship is risky business. How to avoid potential pitfalls. When it comes to operating at peak performance, today's small and growing companies face a variety of obstacles that can prevent them from being successful and from meeting their business goals. In addition to federal and state employment law compliance, there are other systemic pitfalls that can expose a company to risk. Today we're going to discuss the foundational risk that can distract executives from focusing on and achieving their business goals, along with some business best practices for minimizing or eliminating those risks altogether. Again, I'm Roger Royse. I'm the founder of the Royse Law Firm. I'll be moderating our panel today. Our speakers are Shauna Malecki. Our speakers are Jacqueline Breslin, who is the Director of Human Capital Services at TriNet. TriNet is based in San Leandro and is a trusted strategic HR partner to small businesses, providing critical HR-related services on an outsourced basis. Jacqueline has 20 years of experience in human resources. She leads a team dedicated to compliance, workplace investigations, and challenging employee relations issues. She has experience implementing and managing HR functions, which includes policy development, performance management, compensation, recruitment and retention, learning and development, coaching, and M&A activity. Lisa Chapman is a lawyer here at Royse Law Firm. She's represented startup and mid-sized companies for over 20 years in the areas of employment counseling, employment litigation, commercial litigation, trade secret litigation. She's litigated cases involving sexual harassment, discrimination, class action wage and hour claims, and has litigated a wide variety of commercial and employment-related matters. So our format today, as usual, will be a short presentation by each of the panelists. Today we're going to do it a little bit differently, in that we're going to go through a set of materials, and both of our speakers will have commentary and discussion on these slides as we go through them. I want to remind everybody on the webinar that today's presentation is being recorded, and you'll be able to find it after the presentation on our website at royseuniversity.com. It'll also be available as a video on Royse Law YouTube site, as well as available as a download, a podcast download in the iTunes bookstore. So with that, I think I'm going to turn it over to Jackie.
Thanks so much, Roger. So let's go ahead and get started. Our agenda today, we will focus on recognizing and managing talent risk, avoiding risk in the hiring process, and managing risk through effective communication with employees. And we'll also have some time for Q&A. Let's go ahead and move to our next slides, please. So let's review why managing talent risk is important. In 2011, a survey of more than 100 directors at large public companies, financial consulting firm BDO found that boards of directors now count risk management as their top concern. And the Society of Human Resource magazine quoted, that's a quote from SHRM, and most companies recognize that liability can be costly. But it's just as important to acknowledge that dealing with risk in the workplace, whether it's a costly lawsuit or an agency claim, such as a wage and hour or EEOC charge, they really divert an employer's attention. And it takes away the focus of the core business. Managing risks helps to ensure that you're creating a positive and productive work environment, which has implications for your ability to attract and retain top talent. It also can help you avoid potentially embarrassing and distracting public relations challenges. Managing risk can be just as important to your bottom line as other human capital strategies designed to increase your ROI. So let's go ahead and move to the next slide.
Let me add something there, Jackie.
Sure, Lisa.
One other really important thing to keep in mind is that managing your risk in the area of employment, the employment arena, allows companies to focus on their future growth, because it facilitates a company's ability to find new hires and to manage existing employees. Without the ability to obtain new hires and retain current hires, companies simply cannot meet their customers' needs and continue to grow. And this has been identified as one of the very severe limiting factors for a lot of companies right now as they attempt to ramp up and meet the challenges of our more thriving economic structure. Go ahead, next slide.
Here are some numbers that illustrate what we're up against when it comes to attracting and developing and retaining those really key employees and key talent. The U.S. Department of Labor reports that the average cost of bad hiring decisions amounts to about 30% of the new employee's first year's potential earnings. And boy, that can be shocking. And then when we look at, 58% of business owners they know that they need to change policies that they have in place now due to federal regulation changes, and it's hard to keep up with those. $650,000, that's the average jury award in plaintiffs for damages in workplace-related lawsuits. And the last stat, no matter how many times I read it, still always shocks me and causes me to pause, but that 70% of employers are non-compliant with wage and hour laws. So that's certainly a big concern. We can go ahead and move to the next slide.
Jackie, yeah. I would add something to that. In my experience, in that I counsel companies on a daily basis, I would say the number is much greater than 70%. I think almost every company has areas where they are non-compliant, and this means with both federal, state, and local laws and regulations. And one other point I wanted to add to when you say that the average jury award is $650,000, that is just a minor aspect of the damages a company is going to suffer, because typically the litigation costs prior to getting to trial average around $250,000. And that doesn't even take into consideration the incredible amount of time that is wasted by company management simply interfacing with lawyers on a daily basis, preparing for trial, attending depositions, dealing with employee morale issues, and being profoundly distracted as they attempt to go about their daily business, yet are hamstrung by the fact that they've got ongoing litigation. Next slide.
So one of the ways we help, and we as employers can help against reducing risk, is being proactive versus reactive when it comes to employee issues and concerns. The U.S. Equal Employment Opportunity Commission, the EEOC, received a record number of charges of employment discrimination. It's 99,947 charges were filed in 2011, with a record of $455.6 million in relief paid through the program of litigation in 2011, and this number is up from 2010. So that things are not, unfortunately, things are not getting better. Things are getting worse as more claims are being filed, and including the relief that's being paid increasing year over year.
And again, I would just simply echo what I said earlier, which is the amount that you may have to pay to a plaintiff or a claimant is really a drop in the bucket when you think about the increased amount of time spent, which is dollars, and also the legal fees. And also in the case of EEOC claims, it's really important for everyone to understand that when you get a claim by the EEOC asserted on behalf of a former employee or current employee by the EEOC, that if there's a finding against a company, the EEOC is going to stay in your world for about 2 to 3 years and will obligate you to continue to report in and be subject to monitoring activities. So its long-term impact is really quite profound. Next slide. This slide demonstrates that managing risk has indeed become a very high priority for companies. And we've talked a little bit about this. Jackie's already spoken a little bit about this, but the two top concerns of CEOs are talent management, and that is cited as 83.3%, and risk management, which is cited at 77.7%. And these figures are part of a 2011 study of CEOs conducted by PricewaterhouseCoopers. Challenging financial times, as well as very flush financial times, depending on what your industry is, necessitate that organizations become much more attuned to risk in general. There are many risks that are extremely important that show that organizational success relates directly to talent issues. So it's not just what your company does, what it makes, what it sells, it's who are the folks that make up its workforce. That is one of the most important determining factors for success for a company. And unfortunately, talent risks are not always recognized. And the failure to manage this aspect, and that's the talent or human capital aspect of a company's business, has much more negative impacts than almost any other risk that a company faces. Because if a company can't meet its customers' needs, it can't continue to stay afloat, and it certainly cannot grow. Next slide.
So when we look at, so we've talked about the risks exist. What do we do? What can we do to prevent and reduce the risk from being out there? So let's talk about the risks associated with the hiring practice and some ideas and thoughts about how to prevent those risks. So risk number one, untrained hiring managers. So hiring managers represent the company to prospective employees. And so from the moment somebody, a manager at a company speaks to somebody on the phone who's interested in potentially being an employee of your organization, they're representing you, and risk can occur right then and there. There can be strict liability for the company when a manager takes an action that is inconsistent with the company policy or in a violation of law or regulations. So it's imperative to give proper training for hiring managers, new managers, and even long-term managers in the organization. It may be time to brush up on their hiring skills and making sure that they're aware of the company's current hiring policies. Sometimes legal issues arise from unintentional or even well-meaning managers who aren't following company policy. Many times this is because they do not know that the company has a policy. So we really encourage that each organization develop a hiring program that meets its distinctive needs in terms of company culture, available applicant pool, and adopts practices and principles that are consistent time and time again. So every manager is trained on the same process, and every manager is executing on that very same process.
I think that's a very good point, Jackie. Let me just jump back to a reference in your statement. You mentioned that there can be strict liability. And for those of you that are not aware of what this means, it's a legal standard. So there are certain types of liability which are easier for courts to impose and for courts to award damages on behalf of an employee. And strict liability occurs where the type of conduct was so egregious, say for instance sexual harassment, that courts don't require a showing of fault. The court should say you are strictly liable if you sexually harass someone, and you don't have to prove a bad intent. So it's a very low standard of proof. This comes into play by way of example in sexual harassment cases, and it's important for companies to understand that supervisors in California can be personally liable and typically are sued in their individual capacity in sexual harassment lawsuits. So consistent with that, a statute was passed in California several years ago that requires companies with over 50 employees to conduct sexual harassment training for supervisors every year and within the 6-month anniversary of every new hire. So it's important for companies to recognize that it's not just them, the company, that's at risk, but it's also their employees. So they're doing a disservice to their employees by failing to make sure that they are properly trained. Next slide.
Let's talk about employment at will. And it's a very common term and very common phrase. And the working definition is that an employer or an employee can leave their job at any time, with or without reason, with or without warning, and there's that action can be taken, and that would be the dissolving the employment relationship, and it's a decision that an employer can make or an employee can make. And many times when I'm working with our clients, they'll mention they're ready to terminate an employee, and it's that at-will employee, and they're ready to take action. But the truth is, employment at will really means in some ways that an employee can end the employment relationship. it does not take away the employer's responsibility to do the right level of due diligence and protect that employee and comply with federal, state, and local guidelines. And so sometimes when an employment decision regarding a termination wants to be made and resting on the employment at will, the at will premise, challenges can be made, and I know Lisa can take us deeper into that, but it's really important that we do all the right work when we look at the employment relationship and perhaps even terminating employee relationships.
You know, Jackie, it's interesting. Probably the most common question I get from employers is what you just referred to, which is, hey, I've got an employee that's at will under our handbook or the offer or employment letter, and I'm just going to fire that person. And companies wrongly assume that just because someone is considered at will under either California law, which of course is the default position, or under an agreement, that they can blindly terminate folks. Typically, anyone that a company wants to terminate for performance or other reasons is the kind of person that you as a company are going to need to properly document the reasons, the grounds, et cetera, for the layoff or termination. And also, you also are well advised to make attempts to rehabilitate your employees, try and keep them on as long as you can, and so that in the event there is a lawsuit, and it's terminated employees that will bring these lawsuits, you have enough proof in a court of law to show that your intent was proper and that you were not doing what is the basis for a wrongful termination lawsuit typically, which is discriminating against an employee. And by this I mean making an employment decision, hiring, firing, promotion, demotion, etc., based on a protected category of an employee. And this includes age, gender, religion, national origin, sexual preference. The list is very long. Disability, of course. The list is very, very long. And there are also local standards. For instance, in San Francisco, weight is a protected category. So people who are overweight are in a protected class. So when an employer wants to terminate someone, the first question should be, is this person in a protected class? And there's a lot of them, so there's a good likelihood, at least 50% someone's going to be in a protected class. That is when companies need to be very, very careful and just ignore this concept of at will and focus on the fact that you're going to have a good defense, good documentation in writing to support the grounds for your termination. Next slide.
Okay, so another risk, the employee status misclassification. This is an area that I know Lisa and I causes a lot of pause for both of us. And the Fair Labor Standards Act is the act that helps define and direct how employees need to be classified for wage and hour purposes. And based on the employee's duties and responsibilities, it determines, so essentially their job description and their true duties that they do, not just the written job description, but what the employee's actually doing on the job, defines whether they are salaried and exempt from overtime, or non-exempt, hourly with a right to overtime. And when they work, over in California, 8 hours in a day or 40 hours in a work week, for example. And then also, there's another important piece of this, defining whether or not a worker can be an independent contractor or should be an employee of the company based on the duties and responsibilities of that worker, how they need to be categorized. And it's a really important undertaking when you look at how an employee needs to be classified, and it's a step that unfortunately many employers overlook, and they're making fast decisions for their growing company and not slowing down to take a look to see how the employee should be properly classified when it comes to salary or hourly or even independent contractor.
And I would add to that Jackie's analysis of this issue as being one of the most important issues. I completely agree with Jackie's analysis. This is probably the most common mistake that I see. And it's so common and it's so important that the legislature actually passed a statute this past year, California legislature, in which the legislature decided to impose criminal penalties on individuals who improperly classify employees for overtime purposes and other purposes. So it behooves everyone making this decision to make sure that they do it right, because there are fines that can be imposed. We haven't yet seen that play out, but you should expect in the future to see some case law in that. So that's very important. And the other reason why this is an important issue is it leads to the worst possible situation, which is class action lawsuits for overtime loss. And the reason why this type of lawsuit is so damaging and so difficult for companies to deal with is that the legislature enacted a statute that says employees that bring class action wage and hour lawsuits, or even just wage and hour lawsuits for that matter, are entitled to recover all of their attorney's fees. So if you are ever sued for a wage and hour lawsuit and a court finds that an employee is entitled to $1, then all of the money spent by that plaintiff's attorney prosecuting that lawsuit are recoverable. So it is very, very important to follow these laws. And if you get into a class action situation, the settlement ranges are typically well in excess of $500,000, and that would be actually a fairly small settlement. I would also just add one other issue, which is kind of tangential, but this slide sort of brings up in my mind, and that is you're making a decision, not just someone's classification as an employee, but whether or not they're an independent contractor or employee, which also raises the issue of you have to pay them. So if you classify someone as an independent contractor and have a written agreement that you will defer paying them, and if that was a proper classification, that's fine. But if it was an improper classification and a court later determines that that worker for the company was an employee, you will be liable for failing to comply with minimum wage laws. Which brings me to advice I give all entrepreneurs, which is everyone should be paid minimum wage. I understand that, at least in the Silicon Valley, that advice is not typically followed, but it is certainly best practice to try and honor that obligation. Next slide.
So there's a few other risks to consider. We've covered some big ones, but my goodness, there's more. Poor, inconsistent onboarding of new hires. And we know that when employees join your organization, a good first impression is so important. So even from the standpoint, is their equipment ready? Have you outlined what their training curriculum is going to be? Introducing them to everybody. There's sometimes even just simple nuances like that get lost in the process. And what we're really, although there might not be, I'm not talking about unlawful risk in this area, but just the idea of giving employees a really good, good onboarding, good start to your company, and really introducing them to your company culture. The next one, inconsistent compensation packages. So this can be, difficult. There is we know that as, again, with working with fast-growing companies, sometimes they're taking wages from the marketplace. So what do they need to pay this person to attract them, to get them in the door? And then they find out, months or years down the road that they have employees in the same positions earning vastly different wages. And that can then create risk for the company without having the right sort of compliance regarding equal pay around their hires. So those are just some quick examples that worth discussing and worth looking back. And it really comes back to, again, consistency amongst all employees that you're bringing in the door in the hiring process, including onboarding and even defining and delivering compensation packages.
Jackie, one thing I would add to that, and this is a very granular example of something that I think causes more companies problems than any other practice that I see, and that is a failure by companies to actually monitor and document and record the hours worked by employees.
Right.
The courts and the Labor Commission will hold companies responsible if they fail to either have a time clock or have some kind of self-reporting system that's approved by a manager. if you end up in litigation, this failure to comply with this type of best practice will haunt a company. Next slide.
And let's talk about a really consistent process really helps reduce the risk. So following uniform processes and, creating them. If you're not there at that point, after you're listening to us today, you're thinking, okay, I really need to put in place, some hiring guidelines for my managers at my company. That's a great first step. Training your interviewers, there's a lot of great training programs out there. And then also talking about, as a leadership team, what is your training and your interviewing culture going to be like? What are you looking for? What works for you? Using employment applications at proper point in the process. So that can be an important piece, a step that's overlooked. Sometimes companies feel like an application is old-fashioned, but really it's an applicant putting their signature to what they're saying to you is true. And it can be an important step if you're down the line at some point in time and need that level of documentation. You're happy that you have it. Utilizing background checks. And while this, you want to make sure you have the right background check done for the applicant, and that would be checking their education and past employment and criminal checks. And you would always only want to use financial background checks where appropriate, like if, for example, with somebody who's you're hiring a new CFO or somebody to work in your accounting or finance department. And also the importance of creating offer letters outlining the terms and conditions of employment. And this is another area that I see that when a company kicks off and they're starting out, they'll get an offer letter created, and then they won't look back for maybe a couple of years. And those are documents that you should work to keep up to date, making sure as proper language changes in those offer letters that you're also updating your offer letter and the terms of employment.
One of the things that you do need to be aware of is this point, the difference between an offer letter and an employment contract. An offer letter merely sets out the key terms of a prospective employment relationship. So rate of pay, where the person will work, perhaps the scope of duties, who the person may report to. In contrast, the employment contract is the document, the legal document that sets forth the terms regarding the totality of the employer-employee relationship. And like Jackie, I highly recommend that my clients look at these carefully and have us or someone else vet these documents annually. Typically, what we see is that startups crib together documents that they've seen or had been given in their prior employment that oftentimes were written 10 years earlier and don't reflect both current law and or the specific needs of a company and the industry a company works in. And the reference to the last bullet point references an implied contract. That's a contract that is not in writing, and it's not really an actual a situation where Party A and Party B, or say employer and employee, came to specific terms. It's a situation where an employer led an employee to believe that he or she would, for instance, have employment for life or something along those terms. So the written employment agreement, in addition to stating that it is an at-will relationship, the employer can terminate the employee and vice versa whenever they want to. Also, the employment contract should set forth terms which establish what will be grounds for termination in a general sense. Next slide.
So we've covered the pitfalls that you can walk into, step into when it comes to hiring employees, from the interviewing process, deciding compensation, offer letters. Let's talk about, now that you've taken that risk to onboard employees and hire them, what are some of the risks post the hiring process? And one of the areas that we want to focus on is effective communication practices within the organization. So let's go ahead and go to the next slide. So we encourage you to communicate the company core values and goals to employees. And we do see time and time again that there is a disparity between the vision of the leadership team and what employees are executing on. And so the idea to pause and really ensure that the executive leadership team is clearly communicating to directors and managers what their vision is and what the priorities are. That really becomes the basis, besides just the guideposts and the guidelines of the organization and where things are going. It also becomes a measurement about how employees are executing against those goals and those values. Are they buying in? Is the work that they're doing, aligned and in tune with what it needs to be for where the company's going, where they're headed? We know things change fast, and sometimes entrepreneurs don't take the step of really communicating the goals and the mission. But even if you're having to re-communicate and reassign and make changes, that is so much better than the uncommunicated goals and mission of the organization. So based on the vision, managers should be setting goals and clarifying expectations and providing really frequent feedback to employees. This is another step that gets missed, where employees aren't quite sure how they're doing in the organization. And so then there's just, again, this kind of misalignment between the two. And then employees, should be focused on delivering on those expectations and taking the feedback and moving in the direction that they need to for good performance. And then we should also be measuring employees' performance. And again, it goes back to also communicating. And when an employee's performance is not up to par, we need to be talking to them about that and helping them improve that. And we can go ahead and move forward to the next slide, please. Unfortunately, it does seem inevitable that there will be a time where there is an employee who's not meeting expectations, and that can be for a number of reasons. Maybe they don't have the right training. Maybe the direction of the company has changed, and what they were hired to do no longer exists, or there's just a different need right now. The idea that counseling is a really important piece, as I mentioned on the slide before, or just really, communicating performance is an important piece. Sometimes this does become in the form of a counseling to an employee. And while termination is not the goal of counseling an employee, it is at times, the outcome of when an employee can't get on the right track and things aren't improved. But the real purpose behind counseling is to communicate the expectations and feedback to employees, to help that employee succeed and get back on track, and for the manager to be able to commit to that employee in a very succinct way that this is what I need you to work on and this is how I'm going to help you get there. And it gets the employee to correct behavior or their performance, and it can be an important part of employer due diligence. If you find yourself in a situation where an employee needs to be terminated, having the having the legacy and the documented information that you've counseled, you've coached them, you've tried to get them on the right track, you've done everything you could to get this employee on the right track, yet things still didn't happen, you're in a much better place if you need to terminate an employee than if you haven't done this type of work on giving the employee feedback, helping them get on the path. And it's important to document performance and communicate to that employee where they're at.
As a trial attorney, I would have to say that wrongful termination lawsuit, probably the biggest problem that companies face is that they do not comply with this documentation requirement. This alone can cause great heartache for a company. And it's compounded in situations where you've got an employee who, for instance, has a disability or has notified the company that he or she is suffering from a problem. And in those situations, the obligation for documentation is even greater, and I'll discuss that as we go forward. But I would just echo what Jackie said, and that is there is no substitute for proper documentation. Having a verbal conversation and not documenting it and not having the employee acknowledge in writing that the conversation took place really puts companies in a very tough situation when and if they have to face a lawsuit. Can you move to the next slide, please?
So here's just some quick tips on effectively coaching and counseling employees. And it's important to be positive, calm, and direct. And what we mean by that is we don't want you hiding behind the direct message that the employee needs to hear. So if the employee's work product is poor, define what that is like. So are there errors? And be very specific. So have you, in the report that you just reviewed, did you note that there were 10 errors within the entire document? And the expectation would be that there would be 0 errors in the document. And the employee needs really clear guidelines on where the gap is and what it looks like to be successful. And so you want to talk to them about the current state of where things are, what the correct state is, and what you need them to do, and what sort of timeline you need to do that with. And so, in the example of my, of a work product, of a report that has 10 errors in it, the expectation might be that the next report that they turn in is free of errors, 0 errors. And you also would want some sort of guideline in there. So, should they meet with a peer before turning something into you to help with the, with the editing and capturing of those guidelines until they build their skills? So offer the employee support, but be really clear. So in the documentation, you want to identify what the problem is. And let's really stick to data and not feelings in these types of situations. So what was observed? You observed that there was 10 errors in the report. And what's the impact? Is the impact in that situation that you are then spending your time having to rewrite something, or you're having to involve somebody else in another department to rewrite it? But talk to them about the business impact. So this is just not, an arbitrary, you have, very high standards and things need to be 100% correct. I hope that's true, that you do have high standards. But the truth is mistakes in the workplace also have a business impact that we need to clearly communicate to employees also. So what's the corrective action? What's the expectation? Is it 100% error-free the next report? And defining that for the employee is really important, and the consequences of what might happen. What happens next? Is it that they might be moved off the project? Could they be reassigned work? Could they be demoted? Is termination a next step depending on how egregious the situation is and how concerning it is? So really direct communication is the important piece. Direct and documented communication are very important. We can go ahead and go to the next one, please.
I think this slide is really, really important, and I think what it does is it captures a lot of things that Jackie and I have already said before. And this relates to termination and layoff of paid employees. The first bullet is self-evident, and that is that wrongful terminations can be costly. We've already talked about how much the average plaintiff verdict or order of court is for, and we've mentioned the attorney's fees. And it's not just pure economic costs, it's impact on employee morale, distraction, loss of employee time from productive activities. So there are 2 types of terminations. One are voluntary versus involuntary, and obviously voluntary resignations is when someone decides to leave a job. It's considered a lower risk. The reasons could be myriad. The employee is moving on to do something else, is going to school, or is moving. But in a voluntary resignation can lurk an involuntary termination, because an employee can argue, well, you didn't actually terminate me, but because you were so horrible to me, you forced me to voluntarily resign. And that is a subspecies of an involuntary termination. So look carefully at what is going on in each voluntary resignation. And I think the best way to do that is to have a policy where you conduct exit interviews. And I've seen a lot of companies and counseled a lot of companies to have a checklist and ask very specific questions to employees in writing, again, creating evidence if needed, and have the employee sign that document. Why are you leaving? Did you feel that you were promoted? Did you think you were paid fairly? All kinds of questions so that you find out what the employee's position is. And you can use that opportunity, that exit interview, to actually talk to the employee about some of these issues. And if there are problems that are lurking within the employee's responses to the exit interview in writing or orally, you can address them and perhaps salvage the situation. Alternatively, you'll at least have a good record for what was going on. So in the event of an involuntary termination where you, the employer, are exclusively making the decision, of course it's a much higher risk situation. And we've already talked about making sure that you monitor and document the grounds for the termination. It's very common to have a series of disciplinary sessions with the employee where you lead up to the termination, although it's not an obligatory thing. I certainly don't think it's always appropriate. Now, there can be involuntary terminations both based on an employee's performance and or because of a larger business need. Say, for instance, your company is going to go in another direction, you are going to move your labor plant elsewhere, you're restructuring, you're changing how you're going to do business going forward. And in those situations, you have to be mindful of laws that obligate companies when they do a layoff of more than one individual. You have to provide a certain type of notice, and if you lay off a certain number of people, you have to give them wages for a couple of months if you don't give them that notice. I typically advise companies when they're letting go of more than 5 or more people that they do a careful statistical analysis of their employee population to make sure that they're not unintentionally laying off people of a protected category. Say, for instance, you're only laying off women. So it's important to be mindful of the potential discrimination claims that can come out of a termination. So always consider that. Even if it's just one person, am I laying off people of a protected category and keeping people who are not in a protected category? Because that, in fact, is going to be the basis for a litigation, potential litigation. And as the final bullet echoes, which I think Jackie has discussed already, which is be consistent. And I think she's also mentioned this, be fair and kind to your employees in the layoff or termination situation. In my experience, probably one of the biggest reasons that compels an ex-worker or terminated worker to call a lawyer is because they felt that their dignity was robbed and they weren't treated kindly or fairly. So do your best to make sure that you are honoring their dignity when you have to lay them off. Next slide, please.
So we want to review just a few best practices before we move to Q&A. We really encourage you to seek guidance from experienced HR professionals and employment counsel when you're looking at your next steps within your company. You want to be consistent in developing and implementing your policies. Create policies that are compatible with your company situation. So we can't prescribe, a one-size-fits-all type of policy. We really encourage you to create the policies that, are a mirror and a reflection of your company. You want to standardize your process for hiring, onboarding, and performance management. So spending time in each of those areas is really important. Implement appropriate training for hiring managers and really all employees. Lisa mentioned the idea that employees need to be trained for harassment prevention once you reach the 50 employee mark in California. So that would be an example that it's an important compliance point. And establish equitable pay practices using market data and clear, inclusive job descriptions. And also our last bullet point here, document disciplinary and performance issues. And we can go ahead and move to the next slide.
Okay, well, thank you, Jackie. Thank you, Lisa. So to the webinar participants, you'll notice that on your screen there's a dialog box where you can type in questions. So if you have any questions for Lisa or Jackie, go ahead and type those in, send them to us, and we can try to address them now. Also, You can contact the speakers. Any questions that you send to us will be sent directly to the speakers, and they can follow up with you directly after the webinar if you'd like. I want to remind everybody that the webinar is being recorded on the Royse Law YouTube site, as well as on royseuniversity.com/webinars, and again in the iTunes App Store as a podcast for download. So one question that has come in that we have is, what are the greatest risks, particularly the employment risks, not so much for the established companies that have lots of resources to deal with these things, but for startup companies? What do you see as the greatest sort of entrepreneurial risk for startup companies? And why don't we start with you, Lisa?
Perhaps the greatest risk is the failure of the entrepreneur to understand that employment laws can bring a company down. And there are a lot of minimal things that companies need to do when they're lean and they don't have a lot of resources to spend on lawyers or HR professionals. But there are some things they can and should do. The first is they need to document every relationship. Employment agreement and or offer letter is necessary for everyone, and this includes the founders. Number two, they need to pay everyone. I know they are not going to want to, but you really ought to do it. This is a pitfall that is so commonly ignored, and it's really a shame how I've seen a lot of startups literally go out of business because they didn't pay people at all and tried to rely on deferred compensation. I think the third issue is, as a company starts to grow, it gets a little bit of traction. Companies need to put policies and procedures in place. There are minimal things that can be done, that need to be done, and the mere fact that a startup is a new company is just not going to be a good enough defense to failure to comply with laws and regulations.
Jackie, would you like to add to that?
Gosh, that was such a great list, Lisa. I mean, that's really perfect. I mean, I think that again, we go back to the documentation, and I think just a realization that startups and early stage companies are not immune to the employment laws that are out there to protect employees. And I hear that a lot with our clients. They think that, you know, we're small, nobody's paying attention, and I know that's not true based on the work I do, you know, every day here at TriNet.
So here's one question following up on what you said. A listener asked, how do you classify the unpaid startup team members in an unfunded startup? Because oftentimes the founders will work solely for equity and they won't get paid cash. And if they can get a little further down the road, they'll be bringing on quite a few more team members who may not be traditional founders, and they'll work for equity and not get cash, at least not until they get funded. How do you classify those people?
It's a great way of looking at the question, but the real question you need to ask yourself is, am I going to violate California or federal laws and regulations if I do not pay people? So if you're a founder, there are certain tax laws and other laws that allow you to not take compensation for yourself. Certain folks can be classified as officers, and that's another way. Again, I'm not going to give you legal advice on this. You have to see a lawyer in each situation because it varies based on the facts. So it's not whether you classify them as an employee or independent contractor. It's that you need to pay people.
Okay. So, Jackie, suppose we have a company that really wants to better understand how they may or may not be in compliance. How should they approach uncovering potential compliance risks?
So we take an approach with our clients. We do what we call a human capital assessment, where we look at the organization's current practices from the beginning to the end of an employee life cycle, from their hiring practices to their separation practices. And we compare what they're doing against state, federal law, and best practices, and then provide them an assessment with the gaps, and frankly, many times where they're doing great also, and keep up the good work. So that would be the process we use, and I think that that's a good process for other companies to go through, and they can utilize an HR person to do it. I've even seen other organizations that do similar. There's books and articles out there, but take a look. Sit down with what you're doing now and compare it against regulations to find the gaps, and then close those with policies or practices changes to the practices after those things are identified, I think is the best thing to do.
I would add just one thing, and that is when a problem is uncovered, say, for instance, you get sued for wrongful termination, go back and do a much more in-depth analysis at that point, because everything that the company has done prior to receiving the claim for wrongful termination or sexual harassment will be under the microscope of the court. So at that point, go ahead, jump in, do a very deep dive with TriNet or your lawyer or whoever you want to work with, and make sure that you get your company policies and procedures changed at that point.
Okay. So briefly, what are the most, I guess, the most common mistakes that you see companies make, especially ones that maybe are fast-moving and fast-growing and don't have a lot of time and attention and personnel to deal with these issues? Are there some real glaring issues that come up again and again that are pretty easy to spot and maybe care for? You want to start, Lisa?
What I see mostly is the wage and hour violation. That is where most companies make mistakes, and as I indicated, those mistakes are really costly to correct. The employee population at this point is pretty well read on the concept of wage and hour law. I take depositions of people that quote chapter and verse of wage and hour law. So you're dealing with a population that knows what the laws are. So I think that's actually the worst problem that I see. It's the most costly, it's the most common. However, believe it or not, another really common mistake is the sexual harassment conduct of employers and towards employees. One would think that in this day and age, this area of the law would have been played out, but it is still extremely common. And the third thing I see is a combination of 1 and 2, which is a lawsuit relating to both sexual harassment and wage and hour, which effectively ensures that the plaintiff's counsel will receive the fees will be compensated. So that's where I see the biggest risk. And in the part of my practice, which is about half of it, where I counsel companies, that's where I try and focus on making sure that they're compliant with federal and state laws. Jackie, you may have something else that strikes you as also quite important comment.
Yeah, without the risk of being repetitive from our presentation, but I really feel like so much of it lives in the hiring practice portion of it. So I see frequently compensation plans that were not well documented from a commission plan. So as an employee gets disgruntled when their pay is not what they thought it would be, or things or nothing in writing when it comes to the commission plan, and therefore that creating a problem. Steps being skipped in the hiring process, from background checks to applications, and then when something goes sideways in the employment relationship and they can, we peel things back and we look, well, goodness, if a background check would have been done or if the application would have been reviewed more closely, we could have avoided this. Or, if managers would have received better training in the hiring process and interviewing practice, we could have avoided it. Or not putting together, we discover, that a job description was really not well vetted as far as sitting down and thinking about what the person was going to do, and they were hired, and they don't have a skill match because the work up front wasn't done. So I see a lot of things that we work on with our clients live in this area of moving fast and steps being skipped over when it comes to the interviewing, hiring, onboarding process.
Okay. We have a question here about personal liability. And certainly most of the startup companies I see have mentors and advisors. The question is, what kind of liability does a mentor or an advisor, whether it be volunteer or paid, face when they interact with employees? Is that something they should be concerned about?
Mentors and advisors should be concerned, and so should companies. So if mentors and advisors are acting in the capacity as an agent of the company, so if they are representing to, say, an employee that they are affiliated with the company and represent the company, if they violate the law, say they say something or act in a discriminatory manner or whatever they do that violates the law, the company can be liable for the wrongful conduct of the mentor or advisor. Likewise, if the mentor or advisor is acting in a supervisory role, there's a possibility that he or she could be brought in as an individual. My recommendation to the mentor or advisor is to ask the company to carry insurance that protects the mentor or advisor, or to deputize that person as a director or some other high-level role so that if there is directors and officers insurance, that would apply. So the best thing that an individual can do is to make sure that there is insurance coverage, and also to make sure that they are reporting to the company what they're doing so that the company cannot later say, well, that person was a lone wolf doing what they wanted to do outside of the scope of what we asked he or she to do.
And I can tell you from my experience that it's oftentimes very important that we draw that distinction as to whether somebody is going to sit on the board of directors or board of advisors, because one position has authority and potential fiduciary obligation, and the other position, if well characterized, should not. It should be just advisory. And at any given time in this office, we have at least 3 cases where the IRS or a creditor is going after somebody that has that authoritarian role for unpaid payroll taxes, or maybe creditors for creditor claims because of fiduciary risk. So, Jackie, do you have a view on this?
Yeah, I do. It echoes the view that the two of you just shared, and I will say that there's the onus of keeping an employee safe still remains with the employer. So the idea that in case there's any wrongdoing, the liability is also on the employer side. So that would be, example, we've done investigations around harassment where it's been an advisor of the company that has been the harasser or the harassee. So there's a kind of a level playing field from that standpoint that we have to do everything we can to keep our employees safe and our advisors safe too in the workplace.
Okay. So with our last few minutes, I guess I'd ask each of you panelists if you have any closing remarks, any good advice for our listeners here, maybe the top takeaway point from today. And why don't we start with you, Jackie?
Sure. Well, I appreciate the opportunity to speak to the audience today, and I really hope that the takeaway is that you take some time as we close the end of the year to look at your current practices and put in place some good compliance guidelines to end the year well and start the next year off well too. I think it's a great time to sit and pause to see where you're at and put some new compliance practices in place to combat anything that you have going on now that might be, causing you to be concerned.
Lisa?
I echo what Jackie just said, and I would also say to employers, understand the nature of this risk, embrace it, and just start taking it more seriously than you might very well be. It's a distraction from your core business activities, but unfortunately it's one that can bring the company down. So just take it very seriously and jump in and figure out what you're doing wrong as soon as you can.
Okay, I want to thank our panelists here today, Jackie and Lisa, and thank you attendees for attending. Next up, on September 26th, our webinar will be on alternative dispute resolution, arbitration, mediation, litigation. We've got a panel of arbitrators and judges that are going to give an overview as to what the difference is between those vehicles and when one is more appropriate than the other. Again, I'd remind everybody this webinar is recorded for replay on royseuniversity.com. I thank you all for attending, and we'll now end the webinar.